Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Today is July 7th, 2025. Exactly 1 week ago today, June 30th, 2025, the public understood that Mr. Kohberger was preparing to go to jury trial to defend against the 5 counts that had been brought against him in the indictment. So exactly 1 week ago today, as far as the public knew, voir dire was to commence the 4th of August, and it is important to recognize what Mr. Kohberger was standing trial for. It wasn't for second-degree unaliving. It wasn't for felony unaliving. It was for 4 counts of first-degree unaliving, for which he stood the potential for the sentence of the DP in this capital case. There was also the first count. It was for burglary with the intent to commit unaliving. So keep in mind this word, intent. Let's go back and look at what happened in the approximate 2.5 years from December 29th, 2022 on forward. That is a crucial day in this case. 4 items were filed in state court in Idaho. Number 1, the 18-page affidavit of probable cause signed by Detective Brett Payne of the Moscow Police Department. Page 18 included Detective Payne's request for a warrant for Mr. Kohberger's arrest. Then there came the criminal complaint that was based on the affidavit of probable cause, also seeking a warrant for Mr. Kohberger's arrest, and it cited 5 felonies, including 4 first-degree unalivings. Then, also on the 29th of December, Judge Megan E. Marshall entered an order finding probable cause for the arrest of Mr. Kohberger, and then finally the arrest warrant. 1 day later, across the country, Mr. Kohberger was arrested in Pennsylvania, where he was physically that day. He made his first appearance in Monroe County, Pennsylvania. He also had an extradition proceeding where he announced that he would not fight extradition. Extradition meaning he was physically in the Commonwealth of Pennsylvania. The Idaho authorities wanted him returned. They could not go into Pennsylvania and physically bring him back. There needed to be an extradition proceeding. This proceeding didn't happen because he willingly went back. On January 4th, 2023 came the cross-country trip where Mr. Kohberger was taken from Pennsylvania to Idaho, escorted by the Pennsylvania State Police. He made his first appearance in an Idaho court on the 5th of May, 2023, with his counsel, Ann C. Taylor, who had been appointed to serve as his counsel while he was still in Pennsylvania. On the 12th of January, 2023, Mr. Kohberger made his second appearance in an Idaho state court, specifically Latah County. And he appeared before Judge Megan E. Marshall during a brief, approximate 4-minute long hearing. He waived his right to a speedy preliminary hearing. He had been arrested, and now the question was, should he continue to remain in custody until trial or not? Mr. Kohberger's counsel, Ms. Taylor, and Mr. Thompson, on behalf of the state of Idaho, agreed to a 5-day preliminary hearing, which was scheduled to commence in June of 2023. It would start on June 26th and proceed for 5 days. And this would be almost like a mini trial where evidence would be presented by the state seeking to convince the court to bind Mr. Kohberger to keep him in custody until trial, with the defense doing the exact opposite. That preliminary hearing never happened because of what occurred on May 16, 2023. This was approximately 5 weeks before the date of the preliminary hearing and several months after both sides agreed to that preliminary hearing. On May 16, 2023, Mr. Thompson filed the indictment, which was returned by the Latah County Grand Jury. The 5 counts that you see here are what Mr. Kohberger was defending against at this future trial. Now, you will note it is word for word what the criminal complaint signed by Mr. Thompson said. We've received a little bit of information during the time since the grand jury convened, but not a lot. And the bottom line is that Mr. Kohberger was charged with 5 criminal counts. Count 1 for burglary with the intention to commit unaliving, and then the 4 unaliving counts. Count 2 as to Maddie, count 3 as to Kaylee, count 4 as to Xana, and then count 5 as to Ethan. And it is crucially important to look at the elements of what constitutes, what makes up the components of what first-degree unaliving is. Without one of these components, this crime does not exist as it relates to the facts. The 5 components that make up, that comprise, that are the building blocks of first-degree unaliving, as Mr. Kohberger was given notice of back on the 16th of May when the indictment was returned, are as follows. That Mr. Kohberger willfully, unlawfully, deliberately, with premeditation and malice aforethought. Without one of those components, this crime does not exist. We know that this is a conjunctive test, meaning all 5 must be present by the presence of the word and before the 4th and the 5th component or element of this crime. Let's look at the 4th. With premeditation. If you look this up in the dictionary, you will find certain definitions, such as that with premeditation means planning beforehand. Prior to the commission of the offense, there was some meaningful thought. There was some planning that went into place, and malice aforethought. This is crucial in first-degree unalivings. This is the mental element. This is reaching into a defendant's head to determine that he had intended to commit the crime that was committed. Intent is absolutely fundamentally significant in first-degree unalivings. Without these 5 components, it would be perhaps something else, another crime, felony, unaliving, the commission of an unaliving while another felony had happened. For example, burglary, count 1, or second degree unaliving, which does not require the intent component to be here. Now, we know by watching the change of plea hearing, which we as the public learned about exactly 6 days ago when the notice of hearing was entered by the clerk of court in Ada County, telling the world that a hearing would occur on the 2nd of July. You saw Judge Hippler call it to order. You saw him say words to the effect that he had received communications, his staff had received communications from the public encouraging him on how to rule. And he said words to the effect that he rules on 2 things: the facts as applied to the law, and the facts as applied to the law for first degree unaliving requires the elements of willfully, unlawfully, deliberately, with premeditation and malice aforethought. And you saw Judge Hippler refer to the indictment, and you saw him not ask Mr. Kohberger, do you plead guilty to count 1, 2, 3, 4, and 5? He went through each and every element of all 5 of the charges in exhaustive detail. At one point during the proceeding, Judge Hippler said to Mr. Kohberger, I don't want you to plead guilty to a crime that you didn't commit. During the time that Mr. Thompson spoke, he seemed to suggest, and we give our opinion only here, we give our opinion based on the record evidence, the facts, and what happened. The prosecutor did not say that Mr. Kohberger intentionally went to Xana's room, stalked her, tracked her down, and then committed the crime that he was charged with. He said words to the effect that Mr. Kohberger encountered Xana. But more critically, he said words to the effect, we will not represent that he intended to commit the unalivings that he did that night, which was November 13th, 2022. And the question that I posit to you, asking for your pure opinions based on the facts and based on what the record evidence shows and what the indictment stated. Do you believe that first degree unaliving can be present if you were to sit on this jury knowing that intent was not present for all 4 of the first degree unaliving counts that Mr. Kohberger was charged with by operation of the indictment, that the state prosecuted up through the date of change of plea hearing and was apparently prepared to go to trial on? There's nothing else in the indictment. There's no lesser included charge. This is what sentencing, which is scheduled to be on July 23rd, 2025, will be based on. What penalties should be attached to the 5 counts that Mr. Kohberger pled guilty to. And one final thing. Notice, opportunity to be heard, and impartiality are mandated by the 14th Amendment to the United States Constitution. That is the Due Process Clause. It's found in Section 1. Was Mr. Kohberger, in your opinion, properly given notice of the crimes that he was charged with by operation of indictment, or not? If you were a member of the jury What would you think? This is Kathy. Thank you for joining us here today.